Where it stops, no one knows. We're going
everyone, happy Thursday. Welcome back to Criminality. Hi, Marie. What's up, Marshall? Hi, Unindicted. Christy, Carla, BGOG. That's funny. I'm Mila's mom. I Blue Butterfly. Ramblin'. Danielle, did I see how you down here? Maybe I didn't. I don't even know anymore. It's all blurring together. I've had a very long day. Hi, Ramblin'. Hi, Spicy. What's up, Jinx? Hi, Jeanette. Snappy Dragon. Hey, K-Yo. Hi, Marie. Did I ever see? I don't even know. See, I'm like, this is a disaster. I'm going to promise you guys right now this live is not going to be very long. I've had an incredibly exhausting day of life, and I was going to come live earlier. I got this right out the bat this morning, and then some stuff in the family took over, and so I had to leave, and I didn't even get to finish reading it. So I just sat down, skimmed the rest that I had not been able to read, and here we are. So I know that this has probably been read like 15 times on YouTube by this point, but I appreciate you guys all being here. We are going to read through it. I'll read through it as quickly as I possibly can, and then just comment on the parts that I think are the most important. It's very interesting. I mean, it's always such a great learning experience too when we're going through something that we don't typically get to see or be a part of. So it's definitely worth the read if you have not read it. Or have not listened to somebody read it yet. Hi, Sally. What's up, Love to Hunt? Hey, Sarah. Hi, Laura. Does anyone know what happened in Crystal Rogers' trial today? No, I'm still behind on Adam Montgomery's trial from today. So I'm so far behind on the Troconis trial. It's just like a disaster. And so there's not enough time in the day to do anything. You were in court for Harmony? Oh, Ramblin', that's so interesting. How was it? How was it being there? You know, that case is like the super important case to me. Hi, Celestial. Hey, I don't know if I said hi to Shane. Driving again. Oh gosh. So grateful for your hard work. I've learned so much over the past couple of days from you. You're very well. I've learned so much the last couple of days, that especially last night, and I was so thankful that Travis came on. Sarah, Troconis is getting interesting. Yeah, I'm like a week behind. So I was 3 days behind. Now I'm a good 5 days behind, so I got to catch up on that. I think I will go to court on crystals. Did Bob do a live from the airplane? I don't think so. I don't know. Not that I'm aware of. Hey, Tomboy. Oh, it kept buffering. Okay. I don't think so. I know that he was on a plane today, but I think he was still going to do his live when he got there. Harmony is a lot. There's a lot. And the video that I did for Harmony's case, that I just put out a couple days ago, that was hard to even record. It was I don't know how many of you guys have actually listened to the read through of the probable cause and the Harmony Montgomery case. It is so bad. And then I can only imagine, because they don't put everything in there, like how much worse the trial is going to be. And it's not even going to be, I mean, it's not going to be a short trial. It's going to be long. Thank you, Ramblin'. Hey, Kiko. We have the opinion from the Supreme Court on the Delphi case. So we already know what they had ordered, but they have to write an opinion to tell us why they ordered what they ordered. So we now have that. Oh, thank you, Sarah. Wait the hell. Wait the hell. What the wheat? I know I have to make a new one that's got some dirt, some older than dirt. Prepare yourself for opening. The pictures took my breath. I say I did. So I for Adam Montgomery's trial, I am at Uncle Kevin is on the stand. So he has probably only been asked maybe 10 questions so far. Okay, so I know this is a Delphi live, but I'm just going to talk about it for a hot minute because I'm going to do a live kind of to recap the first few days, probably either tomorrow or over the weekend on Harmony's case. So we will dive deeper into it. But I will say, since I listened to the openings today, I was actually quite irritated with the prosecutor. But I know that he was doing exactly what he was supposed to do. I mean, I'm irritated with the whole thing because I hate this case so much. But he just kept talking about like how great Kayla was, and I'm like, Kayla is garbage. They both deserve to be in prison forever. I don't know why he's like, oh, and Kayla's changed and she's so great and she's done all these things for us now. And I was like, no, nope. I'm not buying. You try to, and I know the jury doesn't know but I'm like, try to sell to me that Kayla is some God sent great person. I'm not gonna. The rest of your story is like gonna be shit. That's where I'm at with it. I'm starting Harmony case too, but you keep interrupting. Adam's trial closed down after lunch today. So I did see. Okay, so like I said, I'm just at where Uncle Kevin is on there, and I did see that he has not gone to court. And since he hasn't gone to court, they put out the why, and it's because they want to strip search him, and he's like, "Fuck you, I'm not going then." Jesus Christ, man. I don't know how he gets a choice, but maybe in New Hampshire you do. I'm like, maybe that's how it is. Hi, Kit Kat. Yeah, she needed to be prosecuted too, but she cut a deal and she got 1.5 years, and she's a convicted liar. She's literally a convicted liar, and I just can't. I would love a recap and to experience more creators outside of the Delphi case. Nothing personal. It's just too much division between people I think would otherwise get along. Bossy, I could not agree with you more. And this is one of the things I try to tell people when it comes to, like, especially with Delphi or like any of those types of cases, because there's so much emotion behind the case. And once you have something that like you believe so strongly and it causes like these fights, but I'm like, I did that in another case. And I'm telling you guys, like I literally did that. I fought with anybody who disagreed. I fought in Facebook groups. I fought on YouTube, anywhere. I fought in Discord. Not really. No, I didn't fight in Discord. What was the other thing that they used to have? Patreon, all over the place, because I thought my opinion and what I've researched is like end all be all. So I made it a point that I was not going to do that anymore. And because the next case comes along and all of a sudden I agree with the person that I just was like, that person's a piece of shit. And I'm like, oh shit, now we agree on this case. So are we friends, or like, how do we do this? It gets really awkward. And so if your opinion on the case cannot take over your entire personality, it just can't. So I got this stupid pop-up that doesn't want to go away. But I agree. I think that so many more people would get along if they were talking about a different case. And Mariah, y'all be fighting everywhere on Beyonce's internet. I'm devoted to Beyonce. My daughter would actually be like devoted to Taylor. I'd like to listen to your recap on the Harmony case. Perfect. Well, I'm going to do it because, like, hi, Sleuth Mom. Then Sleuth Mom's channel is actually where I'm watching it. So I think right now there's like one person in her live stream from earlier today, and it's me because I'm so far behind. I'm just like hanging out in the chat still. So funny. I keep looking and I'm like, I wonder if they can actually see that there's one person watching this live, because it's still me. And this is a very big reason, Jeanette, that I try to let everybody's opinions be welcome on the channel. And I think it gets mixed up, because then people think that I'm okay with everybody's opinions about each other, which I'm not. I'm not okay with everybody's opinions about each other. I'm okay with people's opinions on cases. It doesn't mean that I think people need to treat other people like shit. I mean, from somebody who has treated people like shit and somebody who has been treated like shit, I'm trying really hard to not be that person I was. And, you know, it's, I think that kindness is much bigger, and it creates so much more peace. Oh gosh, it's so much more tranquil. Anyway, so hello everybody that's just popped in. Hey, True Crime Fangirl, what's up? Hi, Krista. The way he described Harmony was done was just too much for me. Oh, it's so bad. It's so bad. It's so bad. And that's not even going to be, I mean, there's going to be details that we just have not. Oh, it's going to be so bad. New Hampshire state motto is live free or die. So I guess that applies to strip searching. Yeah, it's like I don't want to be strip searched. Adam pleading guilty to the 2 charges was a great idea by the defense. I think so too. I also think it could backfire. And so you notice that the defense today, and I know everybody's coming in for Delphi, but I'm going to just talk about it just for a second, that the defense was making sure to talk about, to take the emotion out of the case. That's going to be very hard for those jurors, because she is a tiny little 5-year-old with her little cute glasses, and she's just so damn cute. I mean, it's going to be very hard for them to take the emotion out. And him admitting to tampering with evidence and the abuse of the corpse, and, you know, the things that he's admitting that he did do, they're going to want somebody to pay. I mean, it's just, I think it's just human instinct. You want somebody to pay. But I think it was very smart, because now it makes it very clear that he's saying, I did not kill my daughter, and then she did. She did something to her, and I helped cover it up. I don't know. Okay. I wondered this. I wonder if he's going to come and testify. I actually would not be surprised. Now that he has admitted guilt on the other 2 charges, I would not be surprised if he actually testifies. But because he was guilty of that, and they could prove it, I mean, there was no doubt in my mind that they were going to prove that he was absolutely guilty of those 2 charges. I think that he would be like, no, I'm going to come on here and I'm going to say none of this is true. And here's the issue I have. I think they're both pieces of shit. So him blaming her, I'm not going to not believe him. I know that sounds terrible, but I think they both were just terrible human beings. I think they're both terrible parents, and I think they both are completely culpable in the fact that Harmony's not here anymore. Hi, Kiki. Hey, Music Jen. It only takes 1 juror to have reasonable doubt. Yep. I don't know. I've thought maybe he just put pieces and parts in different spots because it was so broken down. Yes, Laura, he's going to say that Kayla did it. Yeah, that's what so you really don't have much to catch up on. So yesterday, now I'm doing a Harmony recap. This is not what this live was supposed to be about. But yesterday they did, essentially just did all the jury instruction, and then the jury went and did the jury views on all the different locations. They just drove around in a bus and stopped at certain spots and looked at places that were going to be talked about in the trial. So that's really all that happened yesterday, except for in the afternoon, Adam, who had refused to come to court, went and said that he was going to plead guilty to 2 of the charges that he was accused of. And so he came on Zoom and pled guilty in front of the judge. So then that way his defense team could use that today for opening statements. So you really just need to watch today. So if you feel like you're too far behind, you're not. Just watch today. Yeah, they're both just garbage. Hi, Christine. He should at least show up to court. I'm never going to believe anything he has to say. Well, yeah, because you got 2 people who are just, like I said, there's 2 garbage human beings, in my opinion. A lot and a half followed true crime for years, but this is probably one of the worst cases I've seen. I think it's one of the worst because of it being apparent and the things that they admittedly, not even just accused, they admittedly do. to her tiny little body. True crime fangirl. See, that's going to be the issue, is I don't think they will, because now you're going to talk about how much reasonable doubt that she would have in her trial based on the fact that they already tried to prosecute him for it. That's the tough part. It's like, that's your one and done. Once you go for it, unless you can develop new evidence, you cannot try somebody else. I mean, you can, you legally can, but like the defense team has a field day if you're trying to do it on the exact same evidence that you already claimed was somebody else's, which would mean that there's reasonable doubt. Gannon Stauch. Leticia Stauch is another one. She just gets me. Like, I have a hatred for that woman. I have a hatred for that woman that's like an unhealthy hatred for another human being, but I cannot stand her. I cannot stand her. And I know my friends are over there going through all of like the calls and stuff, and I'm like, I can't even listen to that. I just want to punch her. I can't stand her. I don't know how they've done it for so long. She's evil incarnate too. Okay, so what is going to start off track? Did you get? I can't even see. Why is this all weird? Anyway, something's like not right with my StreamYard, because I can't see anything up on the top like I normally can. All right. So enough talk about all of that, because like I said, we're going to go over it. If you are somebody who wants to actually watch the trial or catch up on it, my friend, a Sleuth Mom is streaming it. She does a great job making sure all the trials are put out there when it comes to these kids. And her chat is just amazing. So go watch it over there on Sleuth Mom's channel if you are interested in watching the trial. If you are interested in watching recaps of it, I'm going to do them at least a couple times a week. But my friend Alex Erickson, I think, is doing them daily. So, and then Ramblin' is at the trial. Are you Ramblin'? Are you gonna go? Are you gonna continue to go? Let me just ask that, and then we'll get on Delphi. I promise, because I want to get through this. Oh yeah, Casey Anthony, can't stand her either. Can't stand her. Can't stand her. Hi, Teresa. I know a whole bunch of Teresas popped in. Hi, all the Teresas. Yes, I love MJ and Allie, and I love going to their streams, but I can't listen to that woman at all. Right, I just can't do it. Hi, Wata. The defendant can be in the court while the case is tried or not. No weirder than some Indiana laws, I guess. Right. Ramblin' is our boots on the ground, sitting in the court. Our energy into people. It had to be tough today because Harmony's mom testified, and her foster mom testified. Lori Vallow makes you sick. I don't like her either, but she's not. I don't know. I don't have that like weird extra. Like I'm so extra on Leticia. All right. Okay. Get back over here. Hey, Richard. I think you only must be there for sentencing. I would think that I know Leticia had tried at one point to not go to trial, and they were like, no, you're going to be here. Maybe that's just my memory. Seriously, they could have at least found a nice place to put her, as in. Oh, I thought you were talking about Leticia. I was like, wait a minute. For Harmony? Yeah, I thought you were talking about Leticia. I was like, you can bury Leticia. Sorry. Wrong one. Hi, Kyle. Leticia she's just pure evil. She looks like she's coming straight out of hell. Aww. Hey, baby Bill, what's up? Okay, so let's get to this, because like I said, I don't want to keep you guys forever. And then for anybody on replay, I'll timestamp it so you don't have to listen to all the things that you don't want to listen to. So this, so like I said, I started reading it this morning. Hold on, I got to call. Okay, sorry, I hit the camera too. I started reading it this morning. It's a lot of the same history that we already know. So I'll just quickly kind of go through it. And then it talks about, it's the opinion by Justice Moulter, Chief Justice Rush, and then Justices Massa and Goff concur. And Justice Slaughter concurs in part and dissents in part. So anybody who doesn't know what that is, concurs as agrees and dissents as disagrees. So we know that there was, it was unanimous to not do the 70-day, and it was unanimous to not remove Gull. And we know that it was not unanimous to put Baldwin and Rosie back on the case. So now we know that it was Justice Slaughter who dissented, who disagreed. So it was a 4-to-1. It was a 4-to-1 split on putting Baldwin and Rosie back on. So that's interesting. We didn't know if it was a 3-to-2 or a 4-to-1. I think we all feel that way about Leticia. Yeah. So I never liked being a Teresa growing up, but I like it now as long as I don't get called Terry. My sister used to call me Terry when I was little, and that she was the only one that was allowed to do that. I don't like that name for myself. That name is fine for other people. It's just not for me. What's up, Jen? Her lies were evident from the beginning. I'm thankful that Gannon was found, though, to be laid to rest. Luckily, that was like a fluke that he was found. Okay. All right, can you guys see that okay? Let me blow it up one more. I don't want to make it too big because then I won't be able to actually see it myself. Richard, if you try to call me Terry, I'll think you're talking to somebody else. So if you call me Terry, I'm not gonna answer. Okay, here we go. So if I don't see chat for a hot minute, you know why. Oh, hey, other Teresa. Okay, hold on. Hi, Teresa, and all the other Teresas. Shanda Van Ark waived her right to be in the court on one of the days. I don't like being called Terry either. I didn't watch her trial. Right? There's just too many. There's too many going on. Like I said, I still got to go back and catch up on Draconis. When Delphi has to drop docs every single day, and then I'm just like, gosh, I can't even get back to doing the basic things I was doing with going through the damn interviews on Delphi. All right, so Justice Moulter. You know what I should do? Why we do this is so that you guys can see which ones they are. Indiana Supreme Court Justices. Is it in here? I know that when we did the live stream, you could actually just like click on them. So this is Justice Moulter. I feel like he was the one on the far right. If I'm remembering correctly. Okay, I'm going to leave that up. I'll leave that there just so we can kind of peek at which ones are what. So Justice Moulter states, the state charged Richard Allen with 2 counts of murder because he couldn't afford an attorney. The trial court appointed public defenders Andrew Baldwin, Brad Rosie to represent him. But after about a year, the special judge presiding over the case became concerned that they were not representing Allen effectively, so she disqualified them over Allen's objection, replaced them with 2 new public defenders, and continued Allen's trial for at least 9 months so that his new trial attorneys would have enough time to prepare. Allen then retained 2 appellate attorneys who filed a verified petition for writ of mandamus in our court, requesting that we mandate 1, the reinstatement of Baldwin and Rosie, 2, that a speedy trial begins, and 3, that Judge Gull gets removed. The special judge and the attorney general both opposed the petition, and we held an oral argument. After considering all parties' excellent written and oral submissions, we granted Allen's request to reinstate Baldwin and Rosie, but denied his other 2 requests in short order with this opinion to follow. Here we explain our reasons for those 3 decisions. In short, we reinstated Baldwin and Rosie as Allen's court-appointed counsel because the trial court did not find that their disqualification was a necessary last resort after weighing the prejudice to Allen. We denied Allen's request for a trial within 70 days because he did not make that request in the trial court. And we denied Allen's request to replace the special judge because he did not overcome our presumption of impartiality by identifying the facts showing clearly that the special judge is biased or prejudiced. So the facts and the procedural history. This is a lot of what we already know, so I'm going to go through it pretty quickly, but just want to make sure that in case they reference it, you guys know exactly what they're referencing. So the facts and the procedural history. In February 2017, two teenage girls, Abby and Libby, were killed in Delphi, Indiana. 5 years later, in October of 2022, Allen was arrested and charged with murdering them. The trial court judge transferred Allen to the Department of Corrections for his safety while he awaits trial. And then he recused himself from the case. Diener. A special judge was appointed, and because Allen couldn't afford an attorney, the judge appointed Baldwin and Rosie to represent him at public's expense. But a year later, the special judge lost her faith in their ability to assist Allen with his defense effectively. So she ultimately disqualified them as counsel. This right here is where I'm going to struggle, because if the special judge has lost faith in their ability to assist Allen with his defense effectively, and the Supreme Court steps in and says, that's too bad, this is his counsel of choice, does she still feel this way? The special judge, does she still not have faith that they can represent Allen effectively? Does it change her feelings? Because if it doesn't, does that not lean towards bias? That's where I said, this is where I'm going to struggle with that. A leak of confidential case materials, including crime scene photos, triggered the disqualification. Baldwin and Rosie represent that in August 2023, one of Baldwin's friends and former employees, Mitchell Westerman, visited Baldwin's office, secretly copied discovery materials, including crime scene photos. That's good wording right there, because that means that it's outside of the crime scene photos, that there is more to it. They don't tell us what the more really is, but we keep hearing that, so I just keep thinking about it. So it triggered the disqualification. Baldwin and Rosie represent that in August of 2023, one of Baldwin's former friends, Mitchell Westerman, visited the office, secretly copied discovery materials, including crime scene photos, and distributed them to others. After discovering the leak, Baldwin and Rosie notified the special judge and the prosecutor on October 6th. They also explained that after Westerman told Baldwin on October 9th what he had done, Baldwin and Rosie relayed that information to the prosecutor the next day. 2 days later, the prosecutor emailed defense counsel and the special judge informing them that the individual to whom Westerman allegedly provided the materials committed suicide hours after refusing to answer questions from the ISP, detective investigating the leak. The special judge responded to the email by expressing that she was deeply concerned that Mr. Allen's defense is being compromised by all of these recent events. She then directed defense counsel to stop working on the case until the judge could discuss the recent developments with the parties during an October 19th hearing. In the meantime, Allen wrote a letter to the special judge informing her that he had discussed the leak with Rosie and the impact it could have on his defense, but that he wanted Baldwin and Rosie to continue representing him. Counsel for both sides met with the special judge in chambers just before the October 19th hearing to discuss the court's expectations for hearing. During that meeting, the special judge informed Baldwin and Rosie that they had demonstrated gross negligence and incompetence, and conveyed she had grave concerns about their representation of Allen. In support, the special judge says the attorneys failed to safeguard confidential case materials, including crime scene photos. Again, more than just crime scene photos. Emailed confidential work product to an unauthorized person and failed to timely report the leak. That is the Brandon Woodhouse leak right there. Confidential work product. And they didn't report the leak. But like we were talking about last night, if you guys haven't watched that one where Travis pops on, they didn't have to report that because it was work product. It wasn't actual discovery. And when they had an actual discovery leak, they did report it. So I don't know. I know that's neither here nor there with some people, but that's kind of where I'm at with it. The timely report the leak. Made extrajudicial statements about the case. which is I am pretty sure that's their statement prior to the gag order being in effect, which McClelland also did, but everybody seems to forget that, and included inaccurate statements in various pleadings. Well, I think we all know now that the statements that were made are definitely more truthful than inaccurate. Now, do they weigh to the point where Richard Allen should be moved? That's a different situation, but they were not inaccurate statements. They were accurate. Those things were happening. Based on these concerns, the court informed counsel that she had decided to disqualify Baldwin and Rosie, but she offered to let them save face by withdrawing from the case so that she wouldn't have to go into a public hearing a few minutes later and read a statement she had prepared explaining why she believed counsel was grossly negligent and ineffective. Allen was not present for this discussion, but after briefly speaking with Baldwin and Rosie, he relayed through them his objection to the court's disqualification. Since the court presented to Baldwin and Rosie what seemed like a Hobson's choice, withdraw or be disqualified in a publicly humiliating fashion, they conveyed they would withdraw over Allen's objection to the court's disqualification decision. The special judge accepted their withdrawals and conducted a brief public hearing without them, where she stated merely that there was a quote-unquote unexpected turn of events. Yeah, which was absolutely expected by her, and defense counsel had withdrawn from the case. But after having a few days to reconsider and discuss it further with Allen, defense counsel changed their minds, and neither Baldwin nor Rosie ever filed a written motion to withdraw as required by Trial Rule 3.1. Instead, Rosie filed a verified notice of continuing representation notifying the court that he, in fact, would not be moving to withdraw and would continue representing Allen. And he filed a motion to disqualify on Allen's behalf, arguing the special judge was biased and should recuse herself. The trial court struck both filings and ordered the clerk to remove them from the record because Rosie was no longer counsel of record. She also appointed 2 new public defenders to represent Allen. Baldwin then filed a motion to reconsider, also informing the court that he would not file a written motion to withdraw. He did not consider his oral withdrawal effective, and he would continue representing Allen. Baldwin and Rosie both entered new appearances as Allen's privately retained pro bono counsel, but after hearing on October 31st, the court entered an order stating that the special judge previously found gross negligence by Baldwin and Rosie in their representation of the defendant. And nothing has changed in the intervening 12 days that removes the court's grave concerns about their representation. Over their strenuous objections, the court disqualified them from representing the defendant and affirmed the appointment of new public defenders. The court also continued the January 8th, 2024 trial date to October 15th of 2024. On November 6th of 2023, Allen petitioned this court for a writ of mandamus by original action and asked us to, 1, order the trial court to reinstate Baldwin and Rosie as court-appointed counsel, 2, order Allen's trial to begin within 70 days after the writ is issued, and 3, replace the special judge. We heard oral arguments on January 18th, and we issued a writ later that day granting Allen's first request but denying his other 2. So that's everything that led us to this point. In case anybody had missed any of those things, that's a great little summary of everything that got us to that point. The prison issue can go to a federal court, according to Bob, and the new habeas corpus attorney could do that. Yes, could. Doesn't mean it will, but it means they could. So striking things from the record is okay with the Supreme Court. No, so that's actually part of they put it in here because it is discussed in this one, but that was actually part of the first writ of mandamus, the first original action that Kara had filed along with Maggie. And they put in that the court record has to be, clear and concise. They ruled on that, essentially declining the original action, but only because Gull ordered the clerk to put them all back on there. So that one was already decided by these Supreme Court justices. So they already knew that essentially she knew she screwed up. She put everything back on, even though it's not complete and correct according to the standards of the Indiana rules. She did put the ones that were in question back on there. So I think that they just that's not really part of this. It's just history to it, if that makes sense. And hello to everybody that's just popped in. Would they have to charge him federally? I thought about this and was looking into this, Dean, about them charging him federally when they moved him to Wabash, because I was like, that's actually very close to the federal courthouse. Like, are they going to take over? I don't think that they. I don't think they are, obviously, now, but I don't even know if they'd be interested in it and what the criteria would actually have to be for them to do it. I'm just checking what you guys are saying before we move on to the next one. Casey Anthony gets me. He did still to this day. Me too. Everyone just came up from. Oh, hey, Kim. Is he done or is he still going? So the worst leak in history turns out to be no big deal. Take that. The worst. Well, I'll just keep my mouth shut. I'm gonna not say anything. I'm just reading chat, so just give me a second. Oh, what all did I miss? Dean, we really talked more about Harmony and Leticia Stauch, and even a little bit about Casey Anthony. And then we started on this. So we've just read the history, which you know the history. So I read it pretty quick just to get through it. And then we'll go through it and read their opinions. The bridge is federal property. Well, but the property that anything actually happened on was not. Ironically, after the crimes, the small area at the end of the bridge that actually belonged to K. Sanders, K. Weber, the Weber property. It's actually the Sanders property, but people consider it the Weber property. They actually took that as eminent domain and now made it part of the bridge. I think that they could, because of the fact that it's a minor, but they can't. I mean, they can't just. I don't think they can just go in there and just say it's kidnapping, so we're taking it. I don't know that. I have no idea. I started to look into it, and then everybody was like, "No, it's not going federal." And I was like, "Well, I don't know. It's just weird that they moved him there." It belongs to the city of Delphi. Is who owns it. I don't think that makes it. It's not like a national park. I think it just belongs to the city. So I know that if they had crossed state lines, that the federal government could easily come in, but I don't know the criteria. I know that there's a way that they can, because I've seen it happen in other cases. If you guys, I don't know if you guys are familiar with this case, but Cupcake McKinney, they came in and they charged him federally and they charged them locally. If only it crossed state lines, yeah. So I don't know, and I don't believe they crossed state lines in the Cupcake McKinney case. That was just same location, but because of the age, and yeah, well, yeah, that was her nickname, Cupcake McKinney. So they could look at it as a RICO and then do something along those lines, but. Oh, you're very welcome, chicken. No problem. Chicken operas. So many crappy parents, yeah. He tried to give me a shout out, but he kept breaking up. It's like, it's like on the remix. I love Bob. He's got a good soul to me. Okay. All right. So now we're going to get into the discussion about what actually transpired for the hearing. Let me take a drink first. Oh, was that it? Did they cross county lines? I didn't even think they did. I thought that apartment complex was just down the road. Maybe it could have been a different county, I guess. But they did. But they charged them with both. He loves me. He loves me, he loves me not. He loves me, he loves me not. How does Ellie record over interviews just days after the murders? Don't even get me started, Anon. I can't even. So I was looking, so that's a whole nother side conversation. So I was looking up like what could happen now with the recording of those recordings being taped over, and essentially what happens with evidence that is, whether it's exculpatory or not, that is accidentally or intentionally destroyed in a case. So I was pulling up different cases looking at that because it's interesting. There was a case, but it was out of Maryland, that I found that was probably the most, you know what? We'll do a little side project and I'll show you what I'm talking about. So I was trying to find one in Indiana, and then I ended up going to bed. So I didn't get that far. But I'll show you the one that I found in Maryland, which, like I said, it was very close. But it's Maryland, so take it for what you want. It doesn't mean anything here. I'll show you guys. So it talks about, hey Travis, who actually thinks the recordings are gone. Told me inside out what used to be there is there. Yeah, so this was a case, like I said, it's not in Indiana, so you have to kind of just take it for what you want. But it was just an interesting read, and it talks about a 21-year-old was on trial for allegedly sexually assaulting of a 15-year-old, and the detective interviewed the girl and her parents. The police department recorded the interviews, but later deleted them after the detective made a computer keystroke error that resulted in the failure to preserve the recordings in indefinite storage. At the end of both sides' presentation of evidence at trial, the defense asked the judge to issue a missing evidence instruction. That instruction would have counseled the jury that the police had destroyed evidence by failing to preserve the recordings, and that if the evidence's absence was not sufficiently accounted for or explained, the jury actually would have the option to decide that the missing evidence would be favorable to the defense. So what I was reading about just this happening in general was that they could just tell the jury, hey, just err on the side of whoever. Oh, you guys can't even see this. Err on the side of whoever thinks it would favor them. That because it could possibly say whatever they think it said. So the judge actually declined to give this instruction to the jury, and they ended up convicting the guy. They went to the appellate court, and his conviction was overturned based on the fact that the missing evidence was highly relevant. And the prosecutor predicated its case heavily upon the girl's testimony. And given the background, the defense clearly could have used the recordings of the police interviews to call the girl's recollection of events into question and to expose inconsistencies between what she told the jury versus what she had told the detective. So I found that, I mean, like I said, it's not in Indiana, but I found it, like, it was the closest thing I could find. It sounds like a structural error. I mean, it sounds like this is very similar to what is happening right now. And so what does she rule? Does she rule to dismiss the case? From everything I could find, even in Indiana, they don't dismiss the case, but they can take the stand, or the stance, I should say, not the stand. They can take the stance that the jury should err on the side of whoever the evidence could favor. And that's what this appellate court essentially decided to. So that would be like them going into trial and saying Brad Holder said whatever the heck they want to say that he said in the interview because it's gone. I don't know. So I'll do some more research into this too, because I find it very, very interesting. So I just wanted to show you guys that real quick. That was a little aside. What's up, Francis? It's so disturbing. It's so why, but why wouldn't, if they knew it was recorded over back in 2017, why did it take over a year for that to come to light? They could have re-interviewed them, but the problem also would still be, I agree, they should have re-interviewed them no matter what, to at least have something on record. But then you couldn't even compare the first interview to the second interview and see if it was true. And there was the conversation on whether the everything was recorded over. It seemed to me when reading the document yesterday that everything from those two, between those two dates, that everything was recorded over. I would be curious if it just happens to be those two, or if they're just like, delete it all, just delete it all. And then how do you prove that it was deleted then? Like, I wonder if there's something that's in the quote unquote new discovery that was given over that shows that it was deleted then. Like, can they prove that? Does that make sense? Like, after the, so that we don't have the whole conspiracy, because that's what would end up happening is they do these depositions in August. The police now and the investigators now know that they're looking into these Odin people, and all of a sudden those interviews are the ones that come up missing. How do we know they didn't delete them in August, September? Just like the Professor Turco interview. How do we know that didn't happen? There has to be something that's going to be able to prove that, right? That's what I think. Mad at them for destroying evidence. I'm mad at them for hiding the fact that they destroyed the evidence. So when a couple comments that I got on the video when the defense put out the motion talking about that there was quote unquote new evidence. A couple comments that I got were prosecutors will save some of the best stuff till the end because they don't want to give the defense enough time to be able to rebut it actually. So they wait. So now I'm like, wait a minute, if this is quote unquote the new evidence, and the new evidence is, oh shit, we can't give you evidence because we deleted it. God, I just want this damn trial to start. I just want it to start, be over, and we just have the details and we know what the hell happened. Let me see. Just too much shit missing. Yeah, possibly a video digital expert might be able to tell when and how, but will they do that? It could technically be recovered. I don't even know. Do they even have the DVR to recover it from? Hey, okay, you're wrong, but okay, I don't know who you're talking to about what, so I'll let that one slide because I don't know where that conversation was. Hi, Jax. They may be able to tell when it was recorded over by the date of the recording that recorded over the videos interview. Well, they said September. So FBI tried to uncover the evidence, but they couldn't, so they had second interviews. But they didn't. That's the thing, that they didn't even, well, like Patrick Westphal wasn't interviewed again until September of 2023. But if they don't even have this DVR anymore, then what do they do? Probably C-Dub. Yeah, they lost the professor. Was the FBI actually involved in interviews at that date? I gotta go back to the timeline and see when I know the FBI was around right away, but they weren't letting them near like the crime scene and stuff. And they were like, hey, we're here, we're willing to help. And they were like, no. Mm. But they didn't interview Patrick 6 months later, just Holder. Yeah, instead of redoing them, they cleared them. Yeah, what about the GBI? They didn't come until later, right? I think they were brought in. Oh my gosh, like I said, my timeline isn't even. They were brought in later to do the whole we're going back to the beginning, and we're going to go back to the beginning. It was a long time ago, but I remember it happened. FBI interviewed Kelsey 7 times. That wouldn't surprise me. GBI is Georgia. When Georgia came in, yeah, I think that they were brought in to do the whole we're going back to the beginning. Why does the county size of Carroll turn away the FBI help? It's not necessarily unusual. If they tossed it, I would think that they wouldn't have the DVR anymore. That's my GBI was the winter before the new direction. Georgia, a terrible organization, seats Herrick Grinstead case. That case is tough, but they seem to have done a great job on Quentin Simon's case, so I don't want to give them too much. They were involved in that case too. Okay, let's go back over here real quick. Otherwise, we're going to be reading this all day. Okay, yeah, Camille McKinney. Yep, Cupcake. Murderers were convicted of federal kidnapping because she was taken from a housing project funded. Oh. Well, that's interesting. They considered it federal kidnapping because she was taken by a housing project funded by the U.S. So that's the Cupcake McKinney case we were talking about earlier, in case anybody came in after we were talking about it. Okay, so the discussion. As we explained below, we agree with Alan that he is entitled to have his original court-appointed attorneys reinstated. But we agree with the state and the special judge that Alan is not entitled to a writ ordering a trial to begin within 70 days or replacing the special judge. The 70-day thing, I think we all pretty much knew that because they never filed it. And if they were reinstated, they could just go back and file it. And if they weren't reinstated, the new attorneys weren't going to want to file it. So it was kind of just like moot anyway. The two important ones, I think, were the attorneys getting back on and Gold being removed. Alan's request to reinstate his original court-appointed counsel presents extraordinary circumstances warranting relief. Alan argues the trial court exceeded its authority by disqualifying his original court-appointed counsel because disqualification was unwarranted and significantly prejudices both his defense and his opportunity for a speedy trial. The state and the special judge responded that this original action is not the proper procedural vehicle to evaluate Alan's claim, and even if it was, the special judge was within her authority to disqualify counsel because she was rightly concerned that they were not fulfilling Alan's constitutional right to effective legal assistance. They agree with Alan. Our court has repeatedly reviewed attorney disqualification issues through original actions, and we do so here because Alan's petition presents the sort of extraordinary circumstances for which there is not an adequate appellate remedy that our original actional rules require. Essentially saying if they didn't take it to the Supreme Court and they tried to take it to the appellate court, then they're just going to be taking months and months and months to try to do that when now you already have these other attorneys that are invested in the case and have a defense strategy either of their own or adopting the defense strategy from Baldwin and Rosie. They said this when they were in the Supreme Court too, because her attorneys, Gold's attorney, was trying to say like we shouldn't even be hearing this here, and they were like, "Well, we're here, so can we just like thank you for being concerned about our workload, but let's just continue because we're already here." We may review an attorney disqualification decision through an original action. This court has exclusive original jurisdiction to supervise the exercise of jurisdiction by all Indiana courts. These are the things that are important when we talk about the case law that they use going forward. And like I said, no matter whether you think he's guilty, whether you think he's innocent, whether you're on the he's innocent right now until he's proven guilty train, which is kind of more where I'm at. No matter which way you think, these are the important things that are actually happening that are setting what's known as precedent for future hearings. So if another judge in the state of Indiana tried to do something like this, you'll see this original action used in filings later. Like that's how this becomes such a big deal, and why it's not just a boo-hoo Goal, boo-hoo Brad and Andy. Like it's an actual bigger deal for the entire state of Indiana when they're putting it in writing that this is what is required of a judge to do, and this is what's required if a person wants to try to remove a judge and take it to the Supreme Court. Hi, Sleuty. So we exercise our supervisory authority through original actions for writs of mandamus or prohibition. Each writ is an extraordinary remedy. Like it's a bigger deal, equitable in nature and viewed with disfavor. A writ will not be issued unless the relator can show a clear and obvious emergency where the failure of this court to act will result in substantial injustice. That's what I'm saying. They couldn't take this to the appellate court because it would have taken way too long. It would not have been the correct remedy. It would also be issued only where the trial court has an absolute duty to act or refrain from acting, and original actions may not be used as substitutes for appeal. One issue our court has repeatedly reviewed through original actions is whether to disqualify counsel. It's like how they're citing all of these other things that are in here. Eventually, if you follow another bigger case that ends up in the Supreme Court in Indiana, you're going to see this. You're going to see this case. Okay, so they can take on federal. The FBI has jurisdiction to investigate any kidnapping. They can essentially, I would think they could take over anything involving a 12 or younger. They can assist in the older children. The jurisdiction to file in court is a separate issue if interstate. Okay, thank you. No, the part of the opinion is answering the dissenting opinion below. Okay, that's good. Good to know. Okay. Where was I? I lost it. Prosecutor, because the prosecutor's relationship with attorney against whom the defendant and recently testified created an appearance. Okay, this is just going through all the case laws. Affirmatively requested that they be allowed to withdraw if the trial court denied their requests. Declining to issue a writ requiring the trial court to withdraw its order disqualifying the elected prosecutor where the elected prosecutor was a defense attorney for the accused in 2 prior cases. Issuing a writ to remove private counsel retained for a state agency in violation of statute. Okay, so as in those prior cases, reviewing the trial court's disqualification decision here is appropriate through an original action. That is because this case presents extraordinary circumstances where denying a writ will result in substantial injustice, and Allen's petition is not a substitute for an adequate appellate remedy. We reach that conclusion for a few related reasons. For starters, disqualifying Allen's counsel delayed his trial by at least 9 months. And the trial court has already concluded that Allen's pretrial confinement presents extraordinary challenges. I think those are 2 important statements right there. Because disqualifying Allen's counsel delayed his trial by at least 9 months. And now everything else that's happening, that since they have been reinstated, is going to continue to delay it. And we talked about this last night where they said, Justice Rush, her whole point was to get the trial back on track. And everything else that's happening right now is not to do that. Them fighting with each other and doing the contempt and the back and forth, that's not getting the trial back on track. That's them still in the pissing match that they were in back in October, in my opinion, I should say. And the trial court has already concluded that Allen's pretrial confinement presents extraordinary challenges. When did the trial court conclude that? Because they have the trial court, which is Judge Gohl, has the ability. Oh, because I don't. When did it get concluded? Because if it's creating extraordinary challenges, why isn't he being moved? This is I don't get that. I'm like, that doesn't make sense to me. Normally, criminal defendants who must be confined while they await trial are detained in the county jail, while other defendants who are awaiting trial or who have been convicted and receive shorter sentences. But here, for Allen's safety, the original judge transferred Allen to the Department of Correction, which runs our state prisons, facilities that generally detain inmates only after they are convicted and serving longer sentences for more serious crimes. The special judge later reconsidered the original judge's transfer order, and she too found it reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury. And as we know now, as of today, she has also denied Librato and Scremen's request for a transfer. That was denied today with no hearing. The court, having taken defendant's motion to transfer under advisement and having reviewed the state's response, remember, where Nick McClelland's like, I don't have an opinion. I don't have an opinion. Here's my 30 opinions. Remember that one? And now denies the motion to transfer without a hearing. How dare you ask the logical questions? I'm like, that doesn't. When did it even become that they said that it created extraordinary challenges? I don't know. I mean, it does, but I don't think that she ever said that. Allen is being held at Wabash Valley Correctional Facility, which is hours from Carroll County, where the charges were filed, in Allen County, where the special judge serves. Allen's original public defenders and his substitute public defenders have all challenged the conditions of his pretrial confinement, including as they relate to preparing his defense. We are in no position to evaluate the claims in those motions, and the special judge has concluded at least some of Baldwin and Rosie's claims about the confinement conditions are wrong. But even assuming every aspect of Allen's pretrial confinement is proper, and again, we are in no position to say one way or another that it is, extending it for at least 9 months still presents extraordinary challenges for which there is no adequate appellate remedy. Let me just, I'm going to put in here that this whole thing right here is a very important thing about what, in my opinion, we're going to see coming in the future. Bob says it was the previous judge, but I don't think it matters, because what they're repeating the fact that they know, they know, the justices know that it is creating challenges. Both sets of attorneys have said it's creating challenges. They say twice in this one paragraph that they are not in the position to be able to change this. And if you remember, was it who said it? I think it might have been Justice Rush. She was the one who said, when they were talking about that Judge Gold said that that Baldwin and Rosie were essentially untruthful in their requests. The way that she had worded it was they were untruthful, or that some of the things that they had said were inaccurate, or something like that. I'm not quoting it verbatim, but I'm trying. It was like some of the things that they said were inaccurate. And then she turns around and says, that means that some of the things that they said were accurate. And that's still a problem. So I think it's important that this is put in here and a couple times repetitive. I'm going to just throw that out there. That's my opinion. That they're saying we see that there is a problem with how he's being housed. We see that all the attorneys are having a problem with this. But we can't change it. That's my thought. I'm thinking that there's a reason that that's put in here as much as it was. What's more, as we explain in greater detail below, we concluded the trial court lacked the authority to remove counsel without, one, considering other less drastic options, and two, weighing the prejudice to Allen. So not only would Allen's trial be delayed for at least many months, hold on one second. Sorry, I got like a, still have like an itch in my throat. Like the stupid cough doesn't ever want to go away. So not only would Allen's trial be delayed for at least many months if his original attorneys were not reinstated, if Allen were convicted, correcting the disqualification by vacating his conviction and ordering a second trial would produce years of further delay and an enormous waste of time and resources that would not serve anyone's interest, not Allen's, the state's, the victims, the families, the courts, nor the public's. We talked about this so much, and when people were coming in and they were like, you know, the whole "you're being paid by the defense team" nonsense. People who actually want justice for the victims and these victims' families want this process to be done correctly, because if it isn't, the families that all these people care so much about will be doing this for the rest of their lives. Like, I don't know how else to put that. If you want true justice, you do not want the bullshit shenanigans that are happening now. And I try to tell you guys, like, it's separate. Like, it's, for me, the only way I can do it in my brain is it's separate. This right now, what we're talking about, has nothing to do with whether I think Richard Allen is the right guy or not. It just doesn't. Because if they screw all this up, it's never going away. It's never going to stop. Yeah, true justice. You got to do it. You have to do it the correct way. You cannot have these types of shenanigans and then go, oh, well, sorry, families. We really liked Judge Gold, so we didn't really care if you had to go through the appellate process for the next 20 years because we're not going to do it with you. We're going to let you guys do it on your own. Of course, these concerns can generally be resolved through a discretionary interlocutory appeal. Under the appellate rule, appellate will suffer substantial expense, damage, or injury if the order is erroneous and the determination of the error is withheld until after the judgment. The order involves a substantial question of law, the early determination of which will promote a more orderly disposition of the case, and both the state and the special judge argue that this is procedural route Allen should have pursued instead. But Allen effectively couldn't, which is another reason why this matter is extraordinary. They're just talking about why they took it on. I'm reassured that the court said, yeah, removal was not even close to a last resort solution. Right, that there's so many other things that they could do. Such a good point, Tony. Hi, Alley Cat. Something in Indiana changed a couple of years ago, and it was one of the very first states to do it. And I think that they lost the opportunity. So I'm going to go back to what the change was. So the change was that during an investigation, the family, the victims of the crime, had the right to ask a different agency to investigate it. Once there was an arrest, I believe they lose that ability. I'd have to go back and look at. I remember looking at it when it happened and saying, like, they could go and say, hey, we don't want ISP, we don't want Carroll County, we want the FBI, we want this, we want that. They could, but I think once the arrest happened, that was done. I think Gold had advanced copy of the opinion when she ruled on the motion to change judge for bias, because she said in her one-liner ruling, ISC reviewed and found no bias. How did she know? I wondered that, Travis. I was like, how did she know this? How did she know that? They can't make a decision to move him because it's not a relief that was asked for. 100%. That's why I'm like, but there's something in here that they're saying, hey, whoever's paying attention to what we're writing, we know there's a problem. We see it, but we can't do anything about it. So if you really want something done, then go back and do whatever you need to do on your end. That's how I took that last paragraph. On top of disqualifying counsel, the special judge struck their later filings because they were no longer counsel of record, without the ability to file a motion requesting the special judge to certify her order for an interlocutory appeal. Allen's attorneys couldn't pursue that avenue. Yeah, she was just like, I'm going to strike anything that you put on here. So too bad. Go away. To that point, the state and the special judge respond that Allen should have had either his new public defenders or the appellate attorneys he retained for this original action pursue an interlocutory appeal instead. But it isn't clear how either option was feasible. The newly appointed trial counsel had nothing to do with the disqualification proceedings, and Allen wasn't even present for them, so it's not obvious how Allen could work with his new trial attorneys to pursue an interlocutory appeal in the trial court. Maybe Allen's privately retained appellate attorneys could have done so, but it's unclear whether the trial judge would permit them to represent Allen in the trial court along with his new substitute court-appointed counsel. And it's unclear if it would work if substitute court-appointed trial counsel disagreed with the privately retained appellate counsel about whether to seek certification in the trial court. Meaning they didn't want to talk to each other. And as we know, Kara put in there, like there wasn't a lot of communication happening on those two sides. We simply don't expect Allen to untie that procedural knot, and he can't cut through it with this original, action instead. Our prior precedents pointed appellate counsel to the original action tool, and we declined to retire that tool for these sort of situations now. Having concluded that Allen's petition is properly for us, we turn to its merits. And then they have like the oral arguments too. Allen is entitled to the reinstatement of his original court-appointed counsel. Court-appointed counsel may be disqualified only as a last resort after considering the prejudice to the defendant. The Sixth Amendment to the U.S. Constitution and through the 14th Amendment's due process clause and Article 1, Section 13 of the U.S. Constitution, the criminal defendants guarantee criminal defendants the right to have an attorney assist them with their defense. We all know that part. For defendants who can afford to hire an attorney or retain an attorney to represent them for free, that constitutional guarantee includes the right to choose which attorney will represent them. And the erroneous deprivation of this right constitutes structural error, which, unlike other errors, entitles criminal defendants who are convicted to automatic reversal and a new trial. But the right to counsel of choice does not extend to criminal defendants who can't afford an attorney and can't find one to represent them for free. This is saying you don't get to pick your public defenders. We talked about this back when she originally had taken them off, and you do not get to pick your public defenders. You can, I mean, if you're Sarah Boone, you can go through as many attorneys as you want to, but you originally don't get to pick them. And so what they say in the next paragraph is going to be very important, because it's not necessarily about his choice of counsel, it's about his continuity of counsel. So he does have a right to pick them if they were pro bono or he was paying for them. Allen can't afford an attorney, and he has asked us to reinstate Baldwin and Rosie as his court-appointed counsel. Consequently, he has no constitutional right to choose which attorneys will represent him. But he didn't choose Baldwin and Rosie. The trial court did. Allen just wants to continue with the attorneys the trial court chose for him. Stupid cough. Allen just wants to continue with the attorneys the trial court chose for him. He is insisting on the continuity of counsel rather than his choice of counsel. Courts around the country are divided over whether the Sixth Amendment guarantees criminal defendants the continuity of court-appointed counsel, because there is no constitutional right to it. Once established, the interest in maintaining a relationship of trust with counsel is of no less importance to an indigent client than one with ample resources to hire. Our court has been generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. And even courts that have concluded there is no Sixth Amendment right to the continuity of court-appointed counsel have agreed with that much. Essentially saying, once they're on there and once they get this far, it's too bad, so sad. That's who the attorneys are. So you're emailing me something? Okay, let me pull up my email. This is from Shay from Shay Hughes, the attorney that is on Twitter. He also is an attorney in Indiana. He's been on Bob's show a couple of times. I really like this guy. So okay, so this is what he had to say. Nope, that's not what I wanted, but that's fine too. He says, in my opinion, the Indiana Supreme Court has made trial courts more powerful today than ever before with the opinion they issued this morning. This wasn't a mistake. Judge Gall had a considerable amount of time to act and an opportunity to change course. Notably, the court does not reference any case law to support Judge Gall's actions, nor do they represent any case law countering her. To me, evidentiary rules and due process are diminished if a trial court judge can exhibit such conduct but remain on the case. Okay, we're going to have to go back to this because that's where I'm at. That's how I feel. I think that's huge. Oh goodness. Wait a minute. The Supreme Court, there was an order from the Supreme Court that appeared on the docket for Richard Allen, but it now has disappeared. There was? Okay, hold on. Bear with me, you guys. Okay, so 12:07, an order received from the Indiana Supreme Court, and by 12:17, when I went to email you, it had disappeared. When I receive those orders via email, I print out the order, make the event, and scan it. Maybe it's just a glitch. Okay, so that was Tuesday, before she put in... Oh, you gotta be fucking kidding me. Hold on, let me look at the date of this email. This is from February 6th. So February 6th. All right, let me break this down now. Let me bring this over here real quick. Okay, so what apparently... this goes to Travis's comment earlier that he believes that she probably saw something that had to do with the Supreme Court opinion before she actually issued the order here. Well, this is interesting. F-bombs is code for I'm onto something here. Yep. It's true. It's true, Travis. So, okay. So what Sleuthy just sent me these are emails from Sleuthy to the Carroll County Clerk from February 6th. There was an order from the Supreme Court that appeared on the docket for Richard Allen, but it now has disappeared. Any idea what happened to it? Clerk says, I will try and find it, but I need more information. When did it appear on the CCS, and what was it referring to? Sleuthy responds, at 12:07 p.m. today, it popped up and said, order received from the Indiana Supreme Court, and by 12:17, when I went to email you, it had already disappeared. Clerk says, I do not know then. I have not received any notification of a new order from the Supreme Court. Then, on the 7th, the court, having defendant's verified motion to disqualify and defendant's affidavit and the certification of Richard Allen's attorneys under advisement, and having considered the pleadings, now denies the verified motion to disqualify without a hearing, as the Indiana Supreme Court unanimously denied defendant's previous request. I should pull up that actual order. So she actually already had she potentially could have already had it if it was actually posted on the 6th and then removed. I don't know. I mean, it is dated. The one I'm reading is dated the 8th, but I don't know. There's so many fucking shenanigans. I mean, I don't know. Because it did already say unanimous. It did say that it was unanimously denied. All right, let me see what this one is. The one that we couldn't find on Tuesday. Huh. All right, let me come back to you guys real quick. I think it's a possibility that she actually saw something on Tuesday. No coincidence that she just happened to issue her order the day before the Supreme Court issues their opinion. So many shenanigans. You can't make it up. And this is the whole thing when we talk about like their perception of goal and the potential bias is like, I don't believe that she didn't see it. Like my first instinct should be like, no, she didn't see it. She just did this. I mean, not that my opinion is important, but I'm just saying like that should be just the general consensus. Like, no, she didn't see anything. My first thought is she saw it. That means that I think she's biased. I think that I have the perception that she's biased. Okay, let me go back over here. Guarantees that did I read this one? It's the continuity of court-appointed counsel, and have agreed with that much. For example, through the Colorado Supreme Court recently held there is a no Sixth Amendment right to the continuity of court-appointed counsel. It still acknowledged that a defendant's interest in continued representation by a lawyer they have been working with is entitled to great weight if they can demonstrate that prejudice would result from substitution with a different court-appointed attorney. The court concluded that interest flows from the due process guarantees in the 5th and 14th Amendments to the Constitution rather than the 6th Amendment right to counsel. And while the U.S. Supreme Court has not yet addressed whether there is a Sixth Amendment right to the continuity of court-appointed counsel, it too has recognized that the right to due process and counsel overlap. I think that's something that's going to end up having to be done at the United States Supreme Court level. The Constitution guarantees a fair trial through the due process clauses, but it defines the basic elements of a fair trial largely through the several provisions of the Sixth Amendment, including the counsel clause. The Colorado Supreme Court also recognized that before disqualifying court-appointed counsel, the court must determine that any remedy short of disqualification would be ineffective. She did not do that. She did not go as far as to make sure there was no other remedies. Half the shit she brought up in chambers, they didn't even know was a damn issue. It hadn't even been discussed before. In other words, disqualifying court-appointed counsel is a drastic remedy that should only be a last resort. Now, this makes me just go, no wonder McClellan is trying to file this contempt crap that doesn't, what did Travis call him? Ducks and geese. It's got part duck, part goose. Because they're doing everything they can before they remove them, before the disqualification. Courts should therefore disqualify counsel with considerable reluctance and only when no other practical alternative exists. It's also, it makes me think of Chad Daybell, and his attorney was like, I can't get paid anymore, and he's now indigent, and so I need to be off the case, but wait, it's not about the money, maybe I should be on the case, blah, 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 Mr. Pryor. And the judge was like, yeah, I am not inclined to let you leave. I I'm not inclined to let you off of this case because we are way too close. And here the judge is like, no, we're way too close. You got to go. Get off. Get out of here. We're way too close to trial. In other words, disqualifying court upon counsel is a drastic remedy that should only be a last resort. They should disqualify counsel with considerable reluctance and only when no other practical alternative exists. Not just Nikki saying, I think they should be disqualified. The disqualification of defense counsel should be in a measure of last resort, and the government bears a heavy burden of establishing that disqualification is justified. And this approach aligns with how we have treated other drastic litigation remedies that are in tension with parties' due process rights. Courts exclude evidence only as a last resort because that remedy frustrates a trial's truth-seeking function. The trial court has broad discretion in determining whether to declare a mistrial, and ordinarily the prerogative to declare one will be exercised only as a last resort. Okay, so while the state defends the disqualification decision here, it appropriately acknowledges that a trial court's discretion to disqualify court-appointed counsel is significantly limited. The state's brief accurately explains that while varied interests may necessitate overriding a defendant's preference, disqualification is an extreme remedy that should only be used when a court deems it reasonably necessary to ensure the integrity of the fact-finding process, the trial, the fairness or appearance of fairness at trial, and the orderly or efficient administration of justice or public trust or confidence in the criminal justice system. So whether as a product of a defendant's right to due process or the right to counsel, the bottom line is this. A trial court cannot disqualify court-appointed counsel over the objection of both the defendant and the appointed counsel unless A, a disqualification is the last resort, or B, the disqualification is necessary to protect the defendant's constitutional rights, to ensure the proceedings are conducted fairly and within our profession's ethical standards, or to ensure the orderly and efficient administration of justice. And those interests outweigh, I think this is the bigger part, those interests have to outweigh the prejudice to the defendant. This is why you hear that some attorneys want their whole fee up front. It's because they know judge won't let them off the case even if the client has not paid as agreed. Why come and get a house put up? In a previous original action, we said a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel, but we went on to say it was unnecessary to explicate the parameters of that authority. While an original action is not the appropriate vehicle through which to adjudicate or establish a right or to define and impose a duty, here we do find it necessary to explain the parameters of the previously established limitations on the trial court's authority. The framework we describe here mirrors how our court has treated other drastic remedies that may conflict with parties' due process rights, and our concern that disqualifying counsel introduced structural error, at least as it relates to disqualifying them as privately retained pro bono counsel, presents further extraordinary circumstances that prompt us to exercise our jurisdiction now to preserve the integrity of the trial proceedings going forward. Essentially, they talk about the continuity, and then they're talking about the Sixth Amendment right to counsel of your choice. So it kind of goes into both. So that makes me go like this is one of the things I think they just like wanted to reset. So disqualification here was not a last resort. The special judge concluded Baldwin and Rosie made 4 mistakes that demonstrated they would be unable to assist Allen with his defense effectively. 1, they failed to secure confidential case materials, including crime scene photos. 2, Baldwin misdirected an email, he says inadvertently, with confidential case materials to a non-party client without timely reporting the mistake to the trial court or a prosecutor. 3, Baldwin and Rosie made extrajudicial statements while the prosecutor's motion for a gag order was pending, which the special judge thought might prejudice the case. And 4, the statements in Baldwin and Rosie's motion to reconsider safekeeping order turned out to be wrong. But the record does not reflect the special judge disqualified counsel only as a last resort after balancing her effective assistance of counsel concerns against the prejudice to Allen that would result from substituting counsel. First, the record does not reflect that disqualifying counsel was a last resort. Each of the record does not reflect. You're funny. The record doesn't reflect anything. Each of the special judge's 4 concerns could be addressed through a combination of procedural rules and court orders, including the gag order and protective order she entered. And trial courts maintain both statutory and inherent authority to compel compliance with their orders and the procedural rules through contempt proceedings, dun dun dun, and sanctions that include fines and even jail. Recognizing that a trial judge can protect the court against insult and gross violations of decorum by the infliction of summary punishment by fine, imprisonment, or both via a contempt citation. I have to go on and do a balancing gesture. Yeah, it doesn't reflect shit. Okay, recognizing a trial judge can protect the court against insult and gross violations of decorum by the infliction of a summary punishment by fine, imprisonment, or both via a contempt citation. Contempt statutes, indeed, the trial court's protective order invoked the court's contempt power to enforce compliance, ordering that the parties cannot grant anyone access to discovery materials without the court's permission and without the person seeking access first signing an agreement subjecting them to the court contempt powers. There was no finding that these tools were inadequate to resolve the special judge's concerns. Essentially saying she could have done all these things, and if they kept having other issues, then it would have made sense for her to go, okay, you guys aren't fucking listening. Like, you're not doing what you're supposed to do. I'm going to look at something real quick. Hold on. So, his contempt order was put in. When was his contempt order put in? The 29th, right? 28th, 29th. Verify motion to disqualify. Here it is. The 29th. Okay, that's what I was thinking. All right, back over here. Second, the only basis for disqualifying counsel was the special judge's concern that they could not assist Allen with his defense effectively. To be sure, the Sixth Amendment's right to effective counsel imposes a baseline requirement of competence on whatever lawyer is chosen or appointed. Gonzalez. But there is no suggestion that Baldwin and Rosie are out of their depth. Baldwin has over 30 years of experience representing thousands of clients around the state, including clients charged with murder, rape, robbery, burglary, and other violent offenses. And he has tried more than 125 jury trials. Rosie has over 20 years of the same experience, including 3 murder trials and a previous certification to handle death penalty cases. Moreover, neither the state nor the special judge argued that counsel's extrajudicial statements or the statements in their motion harmed Allen's defense. They do argue the disclosure of case materials undermines Allen's defense, but they don't explain how. They don't explain how. And they don't argue these mistakes reflect that Baldwin and Rosie are incompetent to handle Allen's defense or explain why disqualification is necessary to protect Allen's right to the effective assistance to counsel. Notably, neither the state nor the special judge direct us to any case concluding that issues like these, either in isolation or in combination, rendered counsel constitutionally ineffective or were sufficient to warrant disqualification. Third, there is no showing that the special judge's concerns outweigh the substantial prejudice to Allen from substituting counsel. Baldwin and Rosie spent a year working with Allen, investigators, and experts developing Allen's defense, and Allen says he is ready to present it to a jury. The prejudice to Allen begins with the fact that information and momentum spillage is inevitable. As one trial team hands a complicated case like this over to another. Add to that Allen has already been in jail for about a year and a half now. No, been in prison. Allen has been in prison for about a year and a half now. and substituting counsel requires a 9-month delay in the trial date, with substitute counsel unsure whether they would even be ready by then. That is not surprising, given that this is a complicated, high-stakes case. Further, it has already been 7 years since the murders, and fact-finding only gets harder as time passes, memories fade, and evidence is lost. Our disciplinary rules recognize that with the passage of time, clients risk the loss of rights, witnesses, memories fade, and evidence may disappear. The record does not reveal any weighing of these concerns. The record doesn't reveal anything. I just want that needs to be very clear. The record reveals nothing, because the record does not reflect disqualification was a last resort that was necessary after balancing the trial court's concerns against the prejudice to Allen. Baldwin and Rosie must be reinstated. All right, let me see what you guys are saying before we move on to the next part. I'm about to go pull out my magic ingredient. I know an amazing activist. She only deals with one inmate at a time. Ooh, because somebody has asked that. Like that's an interesting. Why aren't any like human rights groups like stepping forward? So embarrassing for us in Indiana. Hey, discount. Let's not get our blood pressure up. They were reinstated, and she was unanimously kept on the case. I wouldn't. I honestly wouldn't. This account, and it's not even my blood pressure necessarily getting up. It's my frustration that the whole point of putting them back on was to get the whole thing. And I'm just going to keep repeating it because that's literally what she said, was to get everything back on track. And I feel like all the other crap now is to make sure that it doesn't get back on track. So this didn't work. So now let's do all these other things to keep it just not moving forward. I don't get that. That's frustrating to me. Like, let's go forward. So, and then there's the whole comment of, well, then they should just, throw down the gauntlet and say, okay, here's 70 days. We're ready for a speedy trial. But you can't throw that down when they're having to now spend their time to, one, defend themselves against shit that was already taken care of, in my opinion, at the Supreme Court level, just like hers was. And now we're going back in this back and forth stuff again, where she's the ultimate sayer of what is going to happen. So just stop and everybody go back to working on the damn case. Leave each other alone. Put on your big girl panties. Go to court. Do the right thing. Do your damn job. And let's go to trial. Yeah, it's completely the opposite way of on track. But they don't want it on track. This is where I'm at. They don't want it on track. And when I say she's the first one who was like, deny, 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 when she should have at least had the hearing. She's the one who told them they needed to do the Franks motion to have the hearing. She's the one who said that. That wasn't from them. They weren't like, oh, hey, we're going to just come up with this whole Franks thing. Like, she wanted it. She asked for it. She told them in June, you have to have it. And then as soon as they put all the thing in, everything that they have into it, whether you agree with it or disagree with it, as soon as they do it, she's like, nope, sorry. And then you've got Nick coming forward with the stupid contempt stuff. You've got them going back to now try to disqualify her. Just come on. Yeah, if she had just said, if they had filed the motion to disqualify and she said, yeah, no thanks, and none of the other outside stuff was actually happening, I'd be like, okay, that actually makes sense because it was filed. She took it off. But I don't know. They cannot file their 70-day because they are too busy now having to defend themselves and still getting discovery that is missing and having to deal with that again. Like, if you guys don't see shenanigans here in this whole fucking mess, I don't know what to tell you. Not to mention that she was going to have a hearing. Yeah, that's also true. She was like, if you guys want to adopt it, let me know, and I'll schedule the hearing. And then she's like, oh, never mind. These guys are back. Sorry. Denied. Allen's remaining request presents no extraordinary circumstances warranting relief. The second request was the trial within 70 days. It was never filed. We've talked about that one so much. It is what it is. It was never going to happen. It's not a big deal. Allen's third request is that we appoint a new special judge to avoid the appearance that the trial court is biased against the defense. but Allen has not stated facts showing clearly that the special judge's disqualification is required. We begin with the presumption that a trial judge is unbiased. This is important. The special judge's, but Allen has not stated facts showing clearly that the special judge's disqualification is required. So they have to begin with the presumption that the trial judge is unbiased. And to overcome that presumption, the party seeking the disqualification must identify facts reflecting the judge's actual bias or prejudice. And as much as we want to say that her just going in there and denying is prejudice, that's not where the actual bias is coming from. Clerk doc again. Scheduling looks like court confers with DA. Shouldn't be. Court rules on motion to change judge already biased based on ISC opinion isn't filed yet. Sleuthie has discovered missing clerk doc again. And the unraveling. Add the unraveling. Who's doxing you? Yeah, they had to go the Frank's route. Hi, Rebecca. Hi, Rose. Is the clerk the only person who adds things to the CCS? The clerk's office, I think, can, but I'm pretty sure she's the only one who actually does it. She's the one who puts it all on there and takes it all off or whatever. Okay, so where are we at? To overcome that, the party seeking disqualification must identify facts reflecting the judge's actual bias or prejudice. Our law is well settled that prejudice is not inferred from adverse judicial rulings. And that is all Allen identifies here, the special judge's adverse ruling disqualifying counsel. This is important. This is important because the reason that she's actually biased is because she tells them that she doesn't think that they're adequate. She doesn't think that they're competent. She doesn't think that they're, she thinks that they're grossly negligent. She thinks they are incompetent. Her telling them that and telling the client that there's no way she can allow them to continue representing him, that is her bias. She can't let that go just because. So this is important because if they don't cite those things, then that means the Supreme Court has no other which way to rule. Can't just do it on the adverse judicial rulings. But she does everything for Nick and she doesn't do anything for us, even though us, the public, are like, come on, give him a fucking hearing every once in a while. But that's not what's important. So it's her comments. It's her comments about how she just absolutely finds them grossly negligent and incompetent, and she cannot let them represent Allen. That's it. That's her bias. Done. No doubt that adverse ruling was significant, but nothing in the record suggests that the special judge's decisions emerged from bias or prejudice against Allen. Just the opposite. The special judge explained that she disqualified the counsel because she was trying to protect Allen's right to the effective assistance of counsel, and we don't minimize her concern. She faced a significant dilemma given her conclusion that the defense were no longer effective. If she left counsel in place and Allen was convicted, the conviction might have been vacated through post-conviction proceedings based on ineffective assistance of counsel. Or if she disqualified the counsel and Allen was convicted, then the conviction might have been vacated because she infringed on Allen's rights to the continuity or choice of counsel. She was in a tough spot either way. I don't think she was in a tough spot quite yet. I think that she could have been, but like they already stated, she didn't go through all the other remedies that she should have gone through first. And like I said from the get-go, she should have just had the hearing immediately. She should have had the hearing. She should have told them exactly what the hearing was for, put it on the docket, and that's it. And we wouldn't even be here. But she was in a tough spot either way. So they see where she was, her dilemma. Though we've determined the record does not support her disqualification decision, we reach the conclusion with, once again, her record doesn't reflect anything. So I don't know why they keep saying that. We reach that conclusion with the benefit of the weeks to consider the issue. Thorough briefing and oral argument from excellent appellate attorneys and the benefit of 5 justices and their staffs poring over the record. That shouldn't have taken very long. Authorities and arguments. The special judge did not have those luxuries. Nor does Allen point to anything suggesting the special judge is biased against Baldwin and Rosie. Of course, she said their mistakes reflected gross negligence, and she was concerned their representation was ineffective. Judicial remarks during the course of a trial that are critical or disapproving of or even hostile to the parties or their cases ordinarily do not support a bias or partially challenge. That is, unless they reveal an opinion that derives from extrajudicial source or reveal such a high degree of favoritism or antagonism as to make their judgment impossible. The special judge said counsel made mistakes that rendered the representation ineffective, but her statements were not based on any extrajudicial source or any experience outside this case. Instead, her statements were based entirely on her observations within this case. And while her conclusion that counsel were constitutionally ineffective was too harsh, she wasn't wrong to be deeply concerned that sensitive case material had been leaked. I don't disagree with that. I just think she went about it completely the wrong way. Though she mistakenly hit defense counsel's eject button instead of the case's lockdown button, she was right to try to get the situation under control quickly and decisively. Her efforts did not reflect any bias or prejudice, and Allen doesn't identify anything she has done that demonstrates she isn't impartial. We therefore deny Allen's request to replace the special judge. Well, my opinion of this is going to be, it's now that the bias is really going to be an issue. I think when they were requesting for her to be removed, it was for the future of bias based on the commentary and the decisions that she had made. That's where I was at. That's where I'm at with it. I don't think that it was necessary that they were like, she's been biased against us from the beginning. I think it's, no, she definitely doesn't like us now, and she can't be impartial. Like we always talked about, like, how do you have both? How do you have Baldwin and Rosie and Goal? No matter which side of the fence that you're on, that one should stay and one should go. How do you have both? I don't know if anybody feels like you can. All right, let's see. If Goal gets disqualified, it will be like a scene out of Wizard of Oz. I'm melting, I'm melting. Sounds like they were going to make it their own, but they talked about agreeing with the Odin stuff regarding the guards, so I think their franks would be pretty similar. They said it would. That's what Librato said. He said that it was not going to be the exact same, but it was going to be similar. That is what they were going to go with. That's what and according to Librato, whether you want to believe him or not is different, but according to him, he said the Odin stuff is real and it's scary, and that he believes that they sacrificed one girl and killed the other. How did they know about the Odin theory on March 5th of 2023? Well, that's tough. That's tough because the Odin quote-unquote theory has been out for a long time. JCM, did they actually state? I'll have to go back and watch. Because did they actually state that the defense was going to go with the Odin theory, or did they just talk about the Odin theory? Because the Odin stuff's been around forever. That's why, like, the people who are like, the YouTubers wrote it and da-da-da-da-da. I mean, I think that the attorneys wrote it. I think there was definitely some typos, but, you know. Goals bias also. You guys, don't be arguing in here. I'm scrolling back up. I don't want to see you guys fighting. Travis, that's what I thought. I'm just trying to wrap my head around Sleuthy getting a notification for IC 2 days before it came out, right? And she just sent me the emails. They're absolutely dated the 6th. So she got notification of something. Now, whether it was this or not, I don't know. We'll never be able to tell. But it's very interesting that there is something. There was something. Yeah, you guys make sure you guys be nice to each other. I don't care about anybody's opinion on the case like that. Don't. Don't make anybody not feel welcome. I hate that I hear that from other people. They're like, I don't know if I can comment in your chat because I don't like that. I want people to be able to just talk. The Odin theory makes no sense at all. Todd, well, I will totally disagree with you. I will totally disagree with you on that. It makes no sense at all. I think it does make some sense. Do I think it's ultimately the right answer? I'm not saying that. But I mean, it definitely has, there's so much to it. And they just keep adding more bits and pieces to it. Okay, nobody's fighting. Okay, good. Okay, so we're at the conclusion. Having granted Allen's request to reinstate his court-appointed counsel and denied his remaining request through our January 18th order, the opinion terminates the original action proceedings in this court for rehearing or motions to reconsider are not allowed. Essentially, this one's done. If you have a problem, you're going to have to come back and start over. That's where they're at, which is if you guys were here last night and Travis was up here, that's essentially what Attorney Osbrook was saying, was like, well, I'll go back. I'll make another one. We'll go back to the Supreme Court if we have to. Like, stop doing shit wrong. Relator Richard Allen. Okay. So here's Slaughters. This is what he concurs with, and then he dissents with. So he is, obviously we know he concurs with the 70-day, and he concurs with the not to remove goal, because those were unanimous and done and nothing to him. So he in concurring means he agrees with the other justices. So all of them agreed that the 70-day gone, and all of them agreed with Judge Gold staying. That's it. Bottom line. Now, he dissents because 4 of the justices say that that Baldwin and Rosie should be back on the case. And he's the one who says he doesn't believe that. So now he's going to tell us why he agrees and why he disagrees with the different parts that the other justices said. He's not necessarily just agreeing with whatever. Mandy, that is one of my favorite lines. Todd, why is the carpet all wet, Todd? Oh my gosh, I can see it now. I think that is something that can be theorized, yes, but we cannot prove it. But to say that it's not possible, we can't do that either. So Richard Allen fails to meet the demanding threshold for obtaining the extraordinary relief he seeks. Oh, I was going to pull up, that's what I wanted to do. I want to pull up Slaughter so you guys can remember which one Slaughter was. Nope, wrong one. Is it this one? Yeah, it's this one. Why is the carpet all wet, Todd? Oh, shit, that's funny. So this was Slaughter. So he was the one on the far left, and he was the one who was telling her attorney, he's telling her attorney, like, thank you for worrying about our workload, but like, we're already here. Let's just go. Let's just do it. So he's the one who ended up being the dissenting vote about them being reinstated. I don't know, Margot. Let me get rid of this. I accidentally popped that back up. So fails to meet the demanding threshold for obtaining the extraordinary relief that he seeks. He establishes neither that the respondents breached a clear legal duty entitling him to an unquestioned right to relief, nor that an ordinary appeal would provide an adequate remedy. Thus, I concur with Part 2 of the court's opinion, which denies Allen's request that we replace Special Judge Francis Siegel and order a trial within 70 days. But I respectfully disagree with Part 1, which orders the reinstatement of Allen's court-appointed counsel, Andrew Baldwin and Bradley Rosie. My objection has less to do with the court's legal analysis than with its bottom-line issuance of a writ. Given the procedural posture in which the issue of an attorney disqualification comes to us, had this issue arisen in an interlocutory appeal or after a final judgment, I would be more open to Allen's argument that the trial court erred in threatening to disqualify his trial counsel after finding them grossly negligent and incompetent. But as that is not the posture of this case, by seeking relief through the vehicle of an original action, Allen takes on the onerous, I don't know what that is, burden of satisfying its exacting requirements. Original actions are viewed with a disfavor and cannot serve as substitutes for appeals. We went through that whole paragraph already. First, the trial judge did not violate an absolute duty in dismissing court-appointed counsel because Allen does not have an unquestioned right to keep them. The Sixth Amendment protects Allen's right to effective counsel. Which includes his choice of qualified counsel. The right to counsel of one's choice, though, it is not absolute, but is circumscribed. I was about to say circumscribed. Is about circumscribed in several important respects. Trial courts have wide latitude to balance this right against competing interests like fairness, our profession's ethical standards, and the court's scheduling needs. The essential aim, after all, is to guarantee an effective advocate for each criminal defendant, and not to ensure that the defendant will inexorably be represented by the lawyer whom he prefers. While the trial judge's actions raise a potential constitutional problem under current law, it is far from clear that she exceeded her authority. The court's opinion admits as much. To justify its award of relief, the court must fashion a new rule against which to adjudge the trial court's actions below. A, the trial court cannot disqualify court-appointed counsel over the objection of both the defendant and the appointed counsel. Disqualification is the last resort. Disqualification necessary to protect the defendant's constitutional rights. We went through all those. And then, having announced its new rule, the court proceeds to find the trial judge breached it. The problem is that this rule did not exist previously. The opinion cites nothing from our court or any court establishing this rule. Yet, despite being unable to identify the source of the rule imposing the supposedly clear legal duty, the court awards extraordinary relief anyway. The court is not even sure of the rule's constitutional source, but the defendant's right to due process or the right to counsel. So he's essentially disagreeing based on that there's no written laws that say, like they were talking about, like there's nothing that says that he has this constitutional right. He also said that he'd be more likely to be looking into it had it gone through the interlocutory appeal and gone that route and was denied. The existence of such duty is anything but clear if the court must patch together its rule out of whole cloth to justify today's result. On the merits, I do not necessarily quarrel with the rule the court announces today. I do not quarrel. It appears to strike a reasonable balance between the competing interests of a criminal defendant's right to counsel and the judge's duty to ensure the defendant receives a fair trial. My beef, I'm not sure that's a legal term. Can we do a poll? How do we make a poll? What do you want the poll to be? I'll make you a poll. What do you want? What do you want? You tell me what you want the poll to be. I wasn't looking in here to see what you guys were talking about. So tell me what you want the poll to be, and I'll make it happen for you. Okay, so I put the poll up. There's a freaking character limit, so I try to just squish it all together. It's essentially saying no, I'm not on mute. I was trying to freaking get it all to work. Sorry. If somehow tomorrow it was unearthed that there was absolute connection between Richard Allen and the Odinism stuff, would the Odinism stuff then become relevant to the case? I guess this is probably more along the lines of all the people who think Odinism is not relevant to the case. So this may be a tougher crowd to get a unbiased answer. So let the record show. Where's the beef? I can't believe you put that in here. My beef. Yeah, they gave me 100, and I needed 101 to even put it the way I did. My beef is rather, it's just not, I mean, such not a legal term. I don't think you're gonna be able to find that anywhere. Rather is with our after the fact application of this newly minted rule to award mandamus relief against Judge Gall, who did not have the benefit of our rule when she acted. So because there was nothing setting that she didn't have the right to do what she did, he's saying, like, Judge Gold didn't even know that there was a rule because there wasn't a rule to begin with, and now there is a rule, and she didn't have the benefit of knowing the rule because there wasn't a rule. I can see that. That makes sense. For this reason alone, I cannot join Part 1. Our original action rules do not permit using a writ when the trial judge's duties are unclear. Like, she didn't know the right way to handle it. I don't know about that. I don't know about that. I mean, this kind of, I think, goes to more to the points of when the justices were asking, like, why aren't you just having us rule on the merit of what she did versus that she wasn't, that she's not allowed to do it. Yeah, that's the outer layer in the onion. If you peel that back, a deeper layer is the investigation. Some investigators saw cult-like Odins, others say no. If that is accurate, it's relevant. Well, we know that some investigators did see it, so does it make it relevant? And did those that see it, I mean, what is their thoughts on Odin stuff? And there was those that didn't see it, did they not know about Odin stuff? You know what I mean? Oh, you've effed up the poll. Oh my goodness. Hold on, let me go back. Defense team will be going to the federal court now that they have proof of bias and a paper trail. It's possible. Sleazy Goosey, that would be a champagne moment. Where's the beef? We aren't tied to Allen. We are tied to the Constitution. And I think that's going to be more clear when we get to when we get back to talking about the case evidence and the case itself against Richard Allen versus what we're talking about now. So these all, I won't vote. So I'm like, this might be a bit of a biased crowd. 85 pages about Odin stuff that these investigators who are respected in their field believe it was. That's why I'm like, put a Todd Click on the stand and have him tell the jury his investigation into the Odin stuff, and I just cannot fathom that somebody's not going to be like, wait a minute, you know, because now you've got law enforcement versus law enforcement. They don't agree. Okay, so now that we know Slaughter has beef, which is also a very interesting connection. His name is Slaughter, and he talks about beef. For this reason alone, I cannot join. Second, Allen does not make the case that an appellate remedy would have been inadequate. This is the other part we talked about earlier, that he thinks that it should have gone to the interlocutory appeal. The interlocutory appeal should have been denied, and then it should have gone to them. This case could and thus should have been brought as an ordinary appeal. Instead, by issuing a writ, we ratify Allen's improper request for a shortcut to an appeal on the merits. Allen should have sought a discretionary interlocutory appeal under the appellate rule when the trial judge dismissed his counsel and barred them from entering a pro bono appearance. There is no reason to presume Allen's original action counsel could not have pursued such an appeal on his behalf. That would have been like Kara and Maggie and Mark. And had Judge Gull refused the request and Alan been convicted, he would have had the ultimate appellate remedy, an automatic reversal of any convictions based on his claim that the judge's disqualification of counsel amounted to structural error. So he just thinks it should have just played out. That Kara and Cruz should have gone in, filed the interlocutory appeal, let her deny it, then him go to trial, and if he's found guilty, go to the appellate court. I mean, he's definitely looking at a long game here. This goes completely against what Judge Rush was saying about getting it back on track and having things done in a speedy manner. I don't disagree with him necessarily. I understand his point. But I think that they talk about how they could not see that being the remedy. The other justices could not see that actually working. Finally, the court rationalizes its writ by claiming we have repeatedly reviewed attorney disqualification issues in original actions. In fact, our case law does not bear out a pattern of issuing writs in disqualification disputes. Of the many cases the court cites, we issued a writ in only 2. In one of those, we disqualified a special prosecutor whose appointed violated a statute forbidding the appearance of impropriety. In the other, we disqualified an attorney whom a state agency hired in violation of a statute requiring the Attorney General to represent the agency. Unlike here, both cases involve the violation of a clear legal right or duty, and but for the writ, counsel's continued representation could have exceeded statutory authority. Well, I think that they're almost looking at the opposite here, because they had to actually go in and disqualify the attorneys and say, hey, no, you cannot be on the case. The court today flouts our original action rules to award extraordinary mandamus relief in favor of Allen against the trial judge. In doing so, we allow Allen to short-circuit the appellate process, muddy our own jurisprudence in this important area, and invite future deviations from our rules. In my view, these institutional costs far outweigh the benefits to Allen. For these reasons, I respectfully dissent from Part 1 of the court's opinion and concur with Part 2. So, it's a great point. And part of the questions by other justices were asking about that. And this is why they asked, to show this justice that it would be just practice. Yeah, it really would be. Because he's essentially saying, yeah, go ahead and waste all the resources. But I get it. I understand he's looking at the longer game. I get it. Because like we've talked about so many times, is what the decisions that are made here are going to be precedent setting for future actions. And so he's looking at it that way. He's just looking at it through a different lens. I don't disagree with him. It's tough because I think that this situation is so not unheard of, and that's not the right word, but it's so rare in all of it that I don't think they could have waited, and it would have just been in a complete waste of all of the resources. And they said it would be a practice hearing, it would be a practice trial, because it's never going to work no matter what you do. If you leave these other attorneys on and Goal is there, unless he is found innocent or found not guilty. If the guy is found guilty, we're doing it again. That's it. The bottom line. All right, let me go back and let me see what you guys got for the poll going on. So that's why I'm like, I don't know if this is the right crowd for this poll, to be honest with you. I would be interested in this poll in some other chats, though. Okay. So what do you guys? What are your thoughts on the Supreme Court's opinion? I want to pull back up what Shea actually said. Now that we're done reading it, I'll read this one more time. In my opinion, the Indiana Supreme Court has made trial courts more powerful today than ever before with the opinion they issued this morning. This wasn't a mistake. Judge Gull had a considerable amount of time to act and an opportunity to change course. Notably, the court does not reference any case law to support Judge Gull's actions, nor do they present any case law countering her. To me, evidentiary rules and due process are diminished if a trial court judge can exhibit such conduct but remain on the case. I think that's, I agree with him too, but I think what the Supreme Court was saying, they only brought up when it came, and I'd have to go back and read it because I haven't read it forever now. The second original action, when they were asking to have Judge Gold removed, they only brought up that she was biased in the rulings on the hearings. And now I think it's a very big difference when the bias is actually what happened in the way that she talked and treated them, especially in open court on the 31st. I don't know if that's actually put in there. I don't think it was as thoroughly covered as some of the other options like RL or KK. I assume it's higher ups making those decisions. If there wasn't something that Odinism, why were Holder interviewed in the first 7 days? Well, as we see from the comments about the search warrant that was created by the prosecutor at the time, which would have been Ives, and it was never executed by the investigators, that they did. Somebody saw that that the crime scene had a religious aspect, potential religious aspect to it. RA's actions after the crimes. Him going to tell them that he was there? I don't know. Maybe you know nothing. Maybe you know nothing. I said nothing because I was reading Little Gambler. Maybe you know something that I don't know about his actions afterward. I want the Odin report. I want the Odin report. He didn't hide. He just went to work. He wasn't hiding. He didn't move. He didn't even move houses. Didn't move out of the city. Didn't move out of the state. Just stayed there and went to work every day. Partied at the bar. I don't think there's lack of anything. Are you talking, Todd, tell me you're not talking about the fact that they were like, we're looking for the car outside of the abandoned CPS building, and then Richard Allen doesn't go forward because he already says, hey, I was parked outside the old building, so he doesn't think, why would they be looking for him? I hide from work, Ivy. I don't know if that does that count? Does that count? I hide. I don't want to do the work, so I'm going to hide. Yeah, the charges aren't. They're not dropping the charges. They're not. No. What you can expect, in my opinion, is that the judge is going to. So that was the other thing that happened today, and I'm sure you guys already know this, but we'll just bring it up real quick just in case. She did order a continuance for the hearing for Monday. It reviewed and granted without a hearing. Transport order is canceled. The hearing is now reset to March 18th at 9 a.m. And still in Allen County, though. Now that she has more time and she's still scheduling in her own courtroom, I think that's weird. I'm telling you guys, I think that's weird. Allen Superior Court, Fort Wayne, Indiana, court to notify, and they'll reissue the transport order for Richard Allen. So that was one. And we talked about that she denied the transfer motion. And then she also tells Baldwin and Rosie that they need to respond to the state's motion to compel discovery, that they have to respond by February 21st of 2024 or provide the said discovery that the prosecutors are looking for. I find that kind of interesting, though, too, because I don't know how it is in Indiana, but I know that there's different rules when it comes to the defense having to give their discovery to the prosecution, and without actually having the trial date's actually in October currently. That's where she's at. That's where it's at. So we got to just leave. I mean, that's where it is. So they just have to respond. I don't know. That one's kind of interesting because I don't know their rules on how closely the defense has to turn over discovery to a prosecutor in the state of Indiana before trial. So they have, I mean, at least she pushed the hearing out. Hopefully Rosie didn't already cancel whatever his personal plans were. War. And so we read through this yesterday where Osbrook comes in and talks about the summary denial of the state's information. This is the live we did last night. And Travis had actually asked about the appearance being filed, but none of it was on the actual court record yet, and it is now. So, or on my case at this point. Dun, dun, dun. There's your memorandum that we just read through. Just making sure I didn't miss anything. I think that's it. So we now have a hearing on March 18th at 9 a.m. to discuss the contempt, which after what came out yesterday, I would be very surprised if Nick doesn't pull it back and redo it. That's what I think will probably happen, because he'll be like, they think I didn't do it right. Or maybe they just already know that that's what's going to happen, and so they just are going to go through with it, and she's going to do what she's going to do regardless. I think that would be interesting, because it would just go to show that they're the shenanigans to postpone this trial from actually happening. These are my thoughts. RA is guilty. Wait, maybe not. Okay. They got the right guy. Well, damn, maybe not. Oh, it's him for sure. Wait, what the fuck? And over again. Long Pony is like you're in my brain. It's like you're in my brain. That's how I feel. I'm like, okay, this totally makes sense. I can see this. I can see this. And then I go and I look, well, what about that? And then what about this? And what about that? What about this? It's literally my brain when it comes to that part. I thought she would wait till tomorrow afternoon. I'll be very honest with you. I really did. I thought she'd just wait. So Alan tells the CO he was there and what he was wearing. Then Alan sees himself on video in the news and don't shit all over himself. Well, he doesn't tell the CO what he was wearing. He just tells him that he was there and that he parked by the old building and he saw 3 girls. He doesn't say what he was wearing until 2022, which I still find very suspicious. How the hell does he know what he was wearing on February 13th of 2017? I mean, I think you could go with a general idea of what he was wearing. Like, I own 3 sweatshirts. So the chances of me wearing one of those, and I don't live in the cold really, so I obviously don't own big jackets or anything, but I'm just saying, like, I would know that I was probably, if it was cold, I was wearing one of those 3 colors. You know what I mean? Yeah. Well, maybe they have now. They already had a professional who analyzed the crime scene, and it has been verified and documented that it was a ritualistic crime. I'm curious about the motorcycle. So I have not been able to find Richard Allen or Kathy Allen owning a motorcycle ever. The thing is her brother passed away in September of 2016 from complications due to a motorcycle accident. She was the one who was the representative of his estate. So did she take his motorcycle? Did they have his motorcycle? I have no idea. But nothing I find shows that he even owned a motorcycle. There's no verification that the girls were dropped off. Okay, so I don't want to get too far into this because this is something else that I've been looking into. There's this whole camera debacle, this trail cam. Holman at CrimeCon, hold on. Holman, when he's at CrimeCon, says they have trail cam pics as evidence. Like, that's essentially what he's saying, that we have the trail cams. Now, we know there's the trail cam that was up at the side of Weber's, on the Weber's side. Everybody keeps saying that's the one that was broken. And then they talk about that there's a Mears camera. Well, I can't figure out a Mears camera that was actually on the Mears side of 300 North. So now I'm thinking, and what I'm hearing, I don't have any proof of this yet, which is why I don't want to go too far into it, is there's a camera that's actually on the other trail pointing towards that Mears parking lot. And this is where they say they have the guy on the bike and they have Derek German. Now, if that's true, and it is that camera, and both the cameras I've said in the past are wrong, If it truly is that camera, that means they do have the girls being dropped off, right? Because they would be right there and other people walking by. So if it faces the Mears parking lot, then it should have Kelsey there with the girls. That happens, Keiki. Sometimes you end up just lurking, which is, it sucks because then people feel that way when they come here, and I hate that. So if they ran the DVR, they wrote over the whole drive probably. The only reason they disclosed those two reports is because they were in the FBI's report. They knew FBI would turn it over. But that's the thing, I guess, for me, is even if it's in the FBI Odin report, do they actually have it? Do they actually have a copy of it? This is where I don't know. Travis, I appreciate you so much. I'm going to wrap up anyway. I got to go cook dinner. So, no, I thank you. And once again, I thank you so much for coming on last night and helping me through that document. It's so, like, now I see it so simply in my mind, but I'll tell you, yesterday when Sleuthy sent it to me, I was like, holy crap, what the hell am I reading? But thank you, Travis. I don't think they have that, because if they did, they wouldn't have to rely on the Harvest store camera to estimate when people got there. That, Ivy, maybe, I don't know. This is what I'm saying. So where's the camera then that has the bike, the guy on the bike, which is, we believe, the McCain brother, but we don't know for sure, and the one that it's the same camera that gets captures Derek German. Is it down the other trail further and not actually facing the store, like the store, not the store, the Mears parking lot that they call it, where Kelsey would have been dropped off? We know they have trail cam because Holman tells us they do. If Rick saw 3 girls, not the 4 that took the bench picture, then that means he saw the first 3 girls who went to play basketball. So he was there way earlier than the prosecution claims. I am very curious about that, Duck and Felonies. I'm telling you right now, we've got to be able to figure out the passing of those, when those girls would have been there. We don't have times. We just know it was earlier in the day, and it's very possible. Mario, you're funny. A witness stated she believes she saw the girls, Abby and Libby, after leaving the bridge where the man in the blue jacket was standing on a platform 1. Yeah, so Betsy Blair goes and walks towards the Monon High Bridge. She sees the young bridge guy out on platform 1. She turns around and walks back, and on her way back, she sees 2 girls who she believes are Abby and Libby walking toward the bridge. Oh, you don't even think there is a camera that has any of them? What crime con was it? Oh, gosh. Ivy making me pull out stuff that I don't remember off the top of my head. It's the one where he's sitting on, so if you're facing them, he's sitting on the far right, and all of them are there. It's one of the very first ones. One of the very first ones. And he's sitting on the edge, and the rest of them are, and I think he's sitting right next to Kelsey. I'll look for it and I'll email it to you if I find it. Thank you, Mother Dragons. Appreciate that. Oh, that's very kind of you. I appreciate it. Around the time Kelsey's car was in the parking lot, that's on camera. They took snap videos, and the girls were there that day and dropped off that day. Yeah, I'm thinking that they have. I'm thinking that we're going to see that they're actually there, but that's me. Okay, hold on. Give me 1 second, and I'll go in here real quick and see if I can find it. If I can find it really quick, I'll just drop it in chat. If I can't, I got to hop off and make dinner. So I know I have it saved in my playlist, though. So let me just see if I can find it real quick. I cannot see chat, so if you guys are talking, I cannot see you, just FYI. Okay, it might be under the family one. Because I have them separated by law enforcement and family, which is kind of a conflict on some of the ones that have both. But there's just so many damn interviews. Let me just look up Holman at CrimeCon. That's the one it is. Hold on. Let me come back to you guys so I can see what you're saying. Dean, I can still look back. What will we talk about when this case is done in like 10 years? It's the one that he has the. He's not. I think it's just in a chair. They're just in chairs sitting on the stage. Now here is the True Crime Design did a short of. This is the one that she does.
And we will continue to do.
Ethan.
I don't want that. I want to see if. Yeah, CrimeCon. It is. It's CrimeCon 2018. So that's the one where he says it. Let me play this real quick.
We'll continue to do that, and we will deal with the stress and the frustration and all the bashing from social media and whoever else. That's fine. Come to us, though. Like they said, come to us. We're trained to deal with that, and we will continue to invest.
He's not talking about the actual evidence. That's when he's talking about something else. No, so look up Delphi CrimeCon 2018. It's when he's sitting. He's sitting on the far left, but if you're facing him, he's on the far right. So that's the one that he talks about that they have the trail cam. All right, I'm gonna go make some dinner. I'm so freaking tired. Thank you guys for being here. Thank you guys for hanging out. I know that this is probably like the 1500th time that some of you have heard that being read through, but I still need to be able to go through it, put it in my brain. You know how I have to listen, I have to read, I have to talk it out. So I appreciate you guys. Go enjoy the rest of your Thursday. I might see you tomorrow for a Harmony Live, actually. This should be cool. Delphi should be quiet tomorrow. We shouldn't be expecting anything. She's already ruled on some of the things. We shouldn't really be expecting anything tomorrow, I don't think. So maybe we'll go live tomorrow night on Harmony so we can talk more about that. All right. Love you guys. Go have a happy Thursday, and I'll see you later.